whether it's a trust or whatever, I say, fine, let me talk to the underwriter. And I usually can work out most title issues, but I go right to the whoever's got the issue. And they want to find out what the issue is. So back to title. How to take and give title, and how to order, how to hold title. So we're going to take a brief lesson in deeds and taking title. General warranty deed. That's the most common deed out there. And it generally is titled general warranty deed. And it uses certain statutory words to make it a general warranty deed. There's more than just these I've highlighted, but this is the main words about the transfer of property, the grant, bargain, and sell, convey, and confirm. And that's a state, their state, deeds and most paperwork is state regulated in terms of what type of title gets transferred. And it has warranties and covenants that go with it. In other words, the grantor, the person who's transferring title, is generally transferring the entire estate, the entire fee simple estate, air rights, mineral rights, rights of possession, all the bundle of rights that go with a piece of real estate. And there's usually no encumbrances except as they may be listed on the title. And it will say, liens of record or anything of record that might have been an easement through the property. But generally, for the most practical purposes, most properties transfer. It might be a utility easement or something on it, but most of them are transferring, the full property's transferring. So, and you receive an after acquired title. So if you general warranty, if the general warranty deed, if you got a general warranty deed after another deed, it would still, since you're warranting that title that you own it and gave it to this party, even if you didn't yet have title, at the time you got title, let's say you provided a general warranty deed in a transaction, and come to find out there was a title flaw, and you really didn't have clear title yet or didn't have title to transfer it. Well, if that flaw gets fixed, that general warranty deed that was recorded would then become effective, because then you had title. This will give it, it's called after acquired title. It gives you quiet enjoyment, and you're ensuring that there's good title, not just while you owned it, but all the way back to when the land was first patented. So when you give a general warranty deed, you're warranting title that the title's good all the way back. Now, we're generally doing that in a title company, and that's why we get title insurance. But you're warranting and saying you'll defend title against anyone that comes forward with a title on that. So, special warranty deed, sometimes called a limited warranty deed in certain states, but a special warranty deed uses slightly different words. And it only warrants the time while you own the property. So basically, what it says is that during my ownership of the property, I warrant that there was nothing other than what's been disclosed or paid off or cleared. Everything has been cleared, and I'm warranting title during the time frame that I owned it. And most people, if you go to a title company, and I sell all the time by special warranty deed, and I've never had a buyer, I can't think of any time where a buyer said, why am I getting a special warranty deed? Because guess what? The title company puts paperwork in front of them and they sign it. But my contract says I want to transfer. When I'm selling one of my properties, I prefer to transfer by special warranty deed, because I wouldn't have to worry about something if something came up previously. Now, it's probably not a big deal, because like I said, most buyers are getting title insurance, and title insurance will cover most of those things that come up. All right, but that's generally what I use when I'm selling. So the other kind of deed, a quitclaim deed. It's not a quitclaim deed, as some folks refer to it, but it's quit. You're quitting claim on a property. The interesting thing about a quitclaim deed is there's no warranty with it. It doesn't say I own the property. It just says if I own it, whatever I own is yours. So I could, the example I always give, I could file a quitclaim deed right now to the Brooklyn Bridge and quitclaim it to all of you. And you would have all of the Brooklyn Bridge that I have, which is nothing. But it's a legal deed to file, I have a recorded legal description, it would be a completely legal filing. But you're not getting anything, you're only getting what I had. So, but they're used a lot of times in the divorce situations, death situations where folks dies and there's uncertainty as to heirs. And so it's, the heirs, I don't know, I don't want to warrant title, I don't know if I have title, did it pass, so that's quitclaim is used to clear up those kind of issues. Now, if you have title, it's as good as a regular deed. You're not warranting it, but it transfers the same, if you have full unencumbered title and you quitclaim it to someone, they get full unencumbered title. It doesn't give them better title. It just comes without a warranty for me. And I'm not going to go to court and defend it if for some reason I only had part of the title or none of the title. So, all right. So let's see. Small on my screen here. All right. So other types of deeds. So there are other types of deeds. Beneficiary deeds. When someone dies, that's a great way to transfer property without having to go through probate. If you've got a simple estate and you've got no argument among heirs or nothing special needs to happen. There's deeding from a trustee from a trust, which you might do in the case if you have your property in trust, a trustee under foreclosure, personal representative in the case of a death, or a conservator, or sheriff's under general execution. So there's a lot of deeds out there that the purpose is to just transfer title. If you get into trust, you're going to have to decide, how do I get the property into my trust? And of course, you should know a little bit about title anyway, even if you never use trust, just to know what's out there and what you can utilize, in your real estate investment. So in Missouri, I don't know if I go into this, Missouri is a deed of trust state. So when we talk about mortgages on a property, it's really generally a deed of trust in Missouri. And that's a security instrument that we give the lender who lends us the money, that says that the lender has an interest in the property. Now, in mortgage states, it's called a mortgage. We call it a mortgage everywhere, but like let's say in Illinois, which actually gets filed as a mortgage, and the lender actually has a lien on the property. The lender has a lien on the borrower's property. In Missouri, most of the time, 99% of the time, it's actually a deed of trust. It's a three-party instrument. There's the borrower, there's the lender, and there's a trustee. That's what we talked about earlier, this trustee under foreclosure. Back it up as trustee under foreclosure. The trustee, there's a trustee in a deed of trust. And sometimes when I'm talking about trust, people will bring up a deed of trust. So I kind of like to talk about that. It's nothing to do with what we do, but in a deed of trust, which is what we it's the security instrument we sign when we borrow from a bank or borrow from someone else. The trustee, the party in that document, is said to hold naked title to the property. So what happens is, even though the title's in your name, the lender's got this deed of trust. The lender really, the trustee holds they hold partial title of the property. It's called naked title of the property. In the event you don't pay, the trustee is allowed to step in and foreclose. All right. So how we take title? So how many people own property in their own name? Show of hands. All right. Most of us have something in their own name. Even I have maybe something. No real estate, I guarantee it. But I do have some things in my own name. How many own an LLC or corporation or other kind of entity? Okay, about half or better of the room. Or you own property with others, husband and wife, or maybe it's joint tenants and common with somebody. All right, so we'll talk a little bit about ownership here. And the reason I'm going into all this is all this kind of plays into how do you decide to title properties? Are you going to title them in your name, with another partner, in an LLC, in a trust? And it matters depending upon your situation. In some situations, a trust may not be the best solution. In some cases, an LLC might not be the best solution. So there are reasons to hold stuff, and knowing the different reasons, the advantages and disadvantages is important as an investor. So sole ownership versus husband and wife. So when you own something in your own name, it feels good. I own this house. It's on the title. So, but there's no privacy. It doesn't avoid probate, but it is easy to finance. Especially if it's a personal residence, probably the easiest piece of real estate out there to finance. Now, could avoid probate if it was a beneficiary deed. You could have a beneficiary deed in your own name, with the proper language on there, it could avoid probate. But generally, it doesn't offer any protection like that. If you own it as husband and wife, it's called in tenancy by the entirety. Where they came up with all these terms, I never quite understood. But what that does is it actually gives you some special protection under the law as your husband and wife. Without going into all the details, basically, if you have a creditor, if you have a judgment against one party, a husband or a wife, and you own your property as husband and wife, it protects them from taking your house. They can't attach and foreclose to your house because of the way this tenancy by the entirety works. Now, on the other hand, if you and a partner owned a house together in your individual names, and one of you got a judgment against you, that creditor could force the sale of the property, tax the property, force the sale of the property, and take that half of the interest. It's, because of that party that had the judgment against them. So husband and wife ownership is actually a pretty good form of ownership as opposed to sole ownership. Now, I'm not recommending getting married just to have a little better privacy protection. So, but you also have no privacy, and it doesn't avoid probate either, unless, like I said, we use a beneficiary deed. But it is easy to finance too. So, and in Missouri, the interesting thing is you don't even have to say that you're husband and wife. It used to be a big deal. You would say, John Smith and Mary Smith, husband and wife. And then, sometimes people aren't husbands and wives anymore. It's John Smith and Mary Smith, a married couple. So they switched the language a little bit. But in Missouri, there was a court case that determined that if you're married and both your names are in the deed, it's assumed that you're a husband and wife, and you get the protection. You get that added protection. So, but we still put it on there if we're going to take title that way. So, owning property with others. So, like I said, I jumped ahead. So, if you own with a partner or third party, our partnership, it's probably not the best arrangement. And even in the legal world, a regular partnership in general, not the best way to go. And I say in general because there are always exceptions to the rule. There's better ways to hold property if you're in I use the word partnership loosely, but partnership can be created by just a couple of people saying, hey, we're going to go on this property together, and then they title it and you start acting in that way. And you can be deemed to be partners under the law. But there's a lot of liability for partners, both partners, if one partner gets in trouble in general. So they're generally jointly liable. And if you guys want to test any of my questions, see an attorney in the room. Like I say, I'm not an attorney, and there's always an exception to the rules, but that would probably be the least favorite way for me to own anything. There could be a title precision suit where a third party or one of the partners sues to split up the title. So it could get really messy if there's a problem. So personal name versus LLC. Look at that a little bit. So there's no asset protection. That's all the things we've mentioned about the personal name, but the LLC does offer some asset protection, as it says in its name, limited liability, and it gives you some privacy. Depends, but that great answer. It might avoid probate. It depends how your operating agreement is worded. And it is hard to finance, and there's some cost to set it up. So, and I know that's a favorite way for a lot of folks to own property. I've owned properties in LLCs, and I still use LLCs today. I just don't use them at the ownership level, at the top ownership level. So they're great tools. So, but you even if you're using LLCs now, you should give some thought to how your operating agreements are drafted. Missouri has a non-probate statute. I'm using the wrong language here, but they have a statute so that you can add language to your LLC and you can transfer your membership interests in the LLC without going through probate. So, but you have to have that document. You also have to have that done in your LLC. So probate's costly. That's when someone dies. Your question? The operating agreement is such a private document. It doesn't get filed with the state. Your organization document does, but your operating agreement, you can amend it. So, that's probably when you would use an attorney to amend it. I've been doing my own LLCs for years, but I used attorneys to create my first ones, and I'm a little bit unordinary as far as I do most of all my own legal paperwork. So I will have an attorney review something if it's something I've never done, or if I just want to get a second opinion. But I've been doing this for a while, and then I still use attorneys, and I think they do a great job, especially people who are attorneys that know what we're trying to accomplish. So, that's something I would use an LLC or attorney for. It's just a paragraph you add in there, depending on how many members are in your LLC, and they can transfer their membership interest should those members die without having to go through probate. All right. So what about trust? We finally get to trust. So here's what you got to remember. Trusts are great for holding things, not generally doing things. So, and they've only been around for almost 4,000 years, so they're not really new. They go way further back than LLCs and corporations and all this crazy stuff we got now. But they're not statutorily created, so there's case law for them. Well, I should say they aren't. In some cases, there's no statute for the type of trust we're creating. They're just based on case law. There are certain trusts that there's statutes for, but the type of trust that we use in Missouri does not have a statute for, although some states do. So, all right. So what is it? What is a trust? Well, it's just a relationship created where one individual directs a trust, appoints a trustee, and there's a beneficiary in the trust. So it's an arrangement between the creator of the trust, the trustee, to handle some kind of asset and do something with it. So that's basically all it is. When you mail a letter, you're effectively, it's a trust agreement. You are putting your letter in the hands of the postmaster and the U.S. Post Office to deliver to who the beneficiary is, the party on the letter. That is really a form of a trust arrangement. So by mailing it, you're entering into an agreement that, okay, I'm gonna put the stamp on there, the post office, they're gonna deliver it to who I want to deliver it to. So that's a good analogy for a trust. And the type of trusts that we're primarily going to talk about are considered a revocable, which means they could be revoked and changed. Grantor trust. Grantor is an IRS term, which basically means we don't have to file. It means we don't have to file a separate tax return in most cases. So it's a flow-through entity. So it is an Illinois type land trust. So be careful if you're looking on the internet about land trusts. There's a lot of different kind of land trusts out there. There's these conservation land trusts that are set up. You have to hold land in perpetuity so they can never be developed and those kinds of things. Those are also called land trusts. That's not what we're talking about here. We're talking about a trust that was created around the concept of the Illinois Land Trust, only because that's Chicago title back in the 1800s created this concept, and it's been adopted by 6 states now where they actually created statutes. But you could create them in any state in the U.S. and because they're valid under trust, common law and under trust statute. So, all right. So now we're personal name versus trust. Well, the trust have a limited liability, but not the same limited liability as a LLC. The trusts that we use, because they're revocable and because we have full control over them, their biggest protection is privacy. When someone looks at the property that I own and it says the Shackelford Joint Asset Holding Trust, XYZA4, what do they think it is? I mean, or the Redbird Preservation Trust, or the Sisters of St. Mary Trust, or I don't know, you just let your imagination run wild. You can name a trust really just about any name you want to. You can't name, you shouldn't use a registered trademark, but, or, some well-known name probably, but because a trust has a creation date, it has a specific trustee, it's holding a specific asset, it's unique in nature by that way. So the trust could have the same name as somebody else's trust because it's not created on the same day and it wouldn't have the same trustee. It also wouldn't be holding the same asset. So, the sky's the limit. You don't really have to go out and check with the Secretary of State and see what there's any other trusts with that name, you just go ahead and name it. And you can name a trust pretty creatively. A name sort of signifies different things. So we'll get into that in the class. It's super private. No one gets the trust but you and your trustee and whoever you want to share it. It's not recorded. No one else knows what's in it. The only thing that would be on title would be the name of the trust and the trustee on a deed and the date the trust was created. So it can avoid probate. Again, it's got to have language in it or have another method of doing that. There is finance considerations, much like an LLC. It's not as easy as financing your personal name. And there's no cost to set it up. Once you learn how to do it, or once you create your first one or two and got help, you know, you've got a print button on your computers, I guess most of you do. And you could probably go out and change the name of the trust, and change the date, and maybe change your trustee. And, you know, if nothing else is changed in the trust other than the asset, maybe it's a different property. You can change the legal description of the property, and guess what? You get a new trust. You print, get it signed, and you put it in your drawer. So it's, you know, I've created hundreds of trusts for myself and others, and you know, once you get to doing it, it's not that difficult. Your first few are it's a little overwhelming, but that's why I teach a class on it, so it's easier to do. So LLCs versus trusts. So they're very similar. The LLC actually has more liability protection because it is a statutory entity. There's laws governing the statutes that protect someone from getting through the assets of the LLC into your pocket if you're one of the members. That's provided you run the LLC property and you don't do anything to pierce the corporate veil. You don't intermingle funds and do all the things you're not supposed to do, put personal funds back and forth in an LLC. But an LLC has that ability to stop lawsuits. The trust, if it's sued, someone can get through that trust. But first of all, it's private. They have to go out. Someone has to really make an effort to get through it. And when they get through it, what are they going to find when they get to the bottom of the trust? So, and that's what we're gonna go on to here. So let's see if we got that here. Okay, maybe I get to that later. Back up here. I haven't presented in about 5 years. I used to, and I changed the presentation some, but I gave this presentation or something similar for about 10 years, every year for several clubs. So, but the marriage between a trust and an LLC is really kind of a perfect storm. What we generally do, and I'm going to say generally, on our investment properties, is we have a trust, and it's a different trust every time. We have a trust for every property, but under that trust is an LLC. So instead of us personally. So if someone did, even if we had something happen, they sued and got through the trust, you're still going to hit the LLC. But guess what? Yeah, they don't even know LLC exists. They got to go to court and find out that there's anything there. And it offers just tons of privacy. You know, your LLCs have got recorded information on and I might get to this in the presentation, but your LLCs, when you create an LLC, when you do your organization papers, you have to list the organizer and you have to list your registered agent. Well, most folks, even if you hire an attorney, unless an attorney knows what we're trying to do, they will put you down as the organizer. So aren't you the organizer of the LLC? Well, you could be. You could organize your own LLC, and you got to have a registered agent, which could be, you know, you could be. It's got to be. You could be you. Could be an attorney. But even when you hire an attorney, a lot of attorneys they'll make themselves a registered agent in case you get served. The registered agent's purpose is only to get served papers. There's a lawsuit, and they'll make generally the person who created the LLC the organizer. Well, that doesn't give you a lot of privacy. If you go out to the website, go to the Secretary of State website, you can see who the organizer is. And it's generally, I say generally, because the organizer does not have to be any member of the LLC. But generally, if it's different from the registered agent, it's a small LLC or whatever, it's generally the people who are the members of the LLC, members of the LLC. So it doesn't give you a whole lot of privacy. If I use an attorney to create an LLC, which I do, but I'll make sure they're both the organizer and the registered agent. So now I have privacy. And attorneys probably create a lot of those. So there was a lot of them out there, but it doesn't attach it to me. It doesn't, I don't have any inkling. If I go out and I'm trying to dig up somebody's information and I look that up, I hit a stone wall. I don't know. It doesn't give me any more information about who might own the LLC. All right, a little bit about trust. So what is a trust? So it's a contract between the creator and the trustee for the benefit of the beneficiary. And it has to meet certain legal requirements to be enforced. It has to meet the same requirements as any contract does, which is pretty easy to accomplish. So, this is the type of trust that we create. It's considered an express trust because we're creating it on purpose, and it's generally in writing. So, you can create an implied trust, like when you mail a letter to the post office. That's more of an implied trust. In certain things in the law, there's applied trust. This is an express trust. We intend to create it. So there's a creator, which is sometimes called the trustor, the grantor, or the settlor. There's a subject matter, which in our case would probably be a property. That could be a real property or a personal property, or both. There's got to be a purpose or intent to create the trust. And there's a trustee, and that's the party that effectively holds title to the trust. And they're also the party that could sign. They're a signatory for the trust. Then there might be multiple trustees. There might be successor trustees and alternate trustees, but that's the person that gets to sign after the property's been put in the trust. And there's the beneficiary of the trust. That's the party that gets the stuff, or it gets the stuff that owns the stuff, or files a tax return. That's the one, the type of trust that we use. That would be you. That would be me, or my LLC. All right, this is the parties that create the trust. Subject matter would be, why are we creating it? What are we putting in there? Let's see if I got that in there. Okay, okay, and that's usually, we'll have a trust agreement or a declaration of trust. That's two common names to see at the top of a trust. Back to my deed days, the general warranty deed. I've seen general warranty deeds that were quitclaim deeds. But guess what? At the top it said general warranty deed. But guess what it was? A quitclaim deed. So the devil's in the details. Just because someone puts a big fancy title up there, especially if you're looking at some paperwork that may or may not have been, may have been, done on somebody's typewriter somewhere, they didn't know what they were doing. It pays to look at the documents. You see some pretty screwy stuff out there in public records you get to look at. I mean, it'll, if you just get bored, just go down to the county courthouse and start combing through stuff. All right, so the trustee. So, yep, goes without saying, this should be someone you trust. And generally, the trustee in most trusts, absent language otherwise, is the party that has some control over the trust. They have some discretionary or sole control over the trust. So, but that's absent of specific language, which we'll talk about. In our trust, the trustee, which is, by the way, not me. When I have a piece of property I own, I am not the trustee. So, and that trustee can't act unless they're being given instructions to act, because we've got language in the trust that says that. So who could be a trustee? So really, anyone who's got the legal capacity to enter into a contract, has to be somebody at least the age of majority of 18 years old, and sound mind, and generally competent, and so anyone who could legally sign a contract can be a trustee. And you could use a corporation, LLC. You wouldn't have specific language in your agreements to do that. I wouldn't recommend that. We generally use individuals for a lot of different reasons. So who could be a beneficiary? Same concept there. And even a beneficiary could be, in many cases, could be, a child or something, but that poses some problems. You want to have then you need a special type of trust where you're going to pass down stuff to maybe a minor or something. You want special language in there because you're going to have someone who can handle the assets for them. If for some reason, the reason for the trust is finishes, and now the child has title of the property, they can't legally signed, and they can legally sign, they just can't, their contract can be voided until they're 18 years of age. So yeah, I've got interesting stories about everything I'm talking about. I can tell you very interesting stories about, people showing up at title companies, and a lady shows up at her title company, she's got her 6-year-old son with her, and you go, hey, well, where's Grant at on title? Oh, this is Grant here. Put her son on title. That's a big problem when you're buying a property. And he can decide the contract to sell it, but he can decide anytime up to he's 18, it can be voided. It's a little bit of a problem for title companies and such. So, but there was an interesting way around that. So, without hiring a guardian and for the person. So the beneficial interest, that's who owns the trust. That's who owns the interest of the trust. And generally, if you're using trust, that's going to be you. It's going to be you. It's going to be your entity. It might be an LLC. And it could be multiple parties. If you have a partnership with somebody, I use the word partnership loosely. I don't mean the legal partnership where you want to do. But if you're in a joint venture of some sort with somebody, you could be joint beneficiaries with different, percentage of interest. Your lender could be a beneficiary. There's a lot of different ways to structure a trust. And I use private lenders, so we get really creative on our trust based on what the lender wants and what I want to accomplish in the transaction. So either from a tax standpoint or from a protection standpoint. So the trust documents, this would be the heart of the trust. This word defines the trust, controls the trust. And really you can do anything in that trust that doesn't conflict with your law. Now it could be a trust to do something illegal. It's like we can't, a contract to sell drugs or to, it could be a contract, but it's not an enforceable contract. So the other documents needed for a trust is once we create a trust, we have to fund the trust, put something in the trust. If you just create a trust and let it sit, it dies on its own. It has nothing in it. Fairly quickly after you create a trust under the law, you're supposed to put something in it, fund the trust. Now you could put, I think Roger and I heard one day, you can put a piece of lint in it, but you have to define that you put that piece of lint in it. Now this trust has a purpose and it's holding something. Of course, that's just an exaggeration, but without funding the trust would effectively die within a short period of time. So generally, if we're real estate, we're going to deed it in the trust. And we might decide to use a warranty deed or a quitclaim deed, depending upon our circumstances. We also need to appoint a trustee. We might use an affidavit of trust or certificate of trust. When I sell a property with a title company, I don't give them the trust documents, except on occasion. Rarely do I give them the trust documents. I give them a certificate or affidavit of trust. So even they don't have the full information on the trust. Generally, when you're selling, it's not a big deal because you're dissolving that trust. When I'm buying, I like to keep it private. If I'm buying in a trust, I don't tell the title company who the beneficiary is or anything about the trust. I fill out the certificate of trust, which is allowable in state statute, provide them certain information that they have to ensure title. So, and really, they attorneys, who owns title companies? Attorneys. And attorneys ask for everything. And then they just keep what they don't need. But in many cases, they don't need everything. Especially when they're carrying out a specific duty. Now, if you hire your attorney to defend you in a case or something, you need to give them everything and the kitchen sink, because those little details that you don't think about could be really valuable if you're defending a case. But when attorneys in the case of a title company is just transferring title or insuring title, they don't need everything. They need enough to satisfy their underwriter. And they do have to have some documentation of the trust. What do you think is most important that they have good records on the trust when you're buying in the trust or selling out of the trust? Okay, he says buying. Who's in for buying? Who's in for selling? A few more hands on selling. So it's actually selling, and the reason is when you buy it. And you provide the title company with your contract that says you're buying a property, you're buying it and putting it in a trust. You're giving them instructions to put it in this trust. They might ask for the trust. They will certainly ask for a certificate of trust. But you made the decision about how to title it. You created some trust. It's really, they didn't create it. So they're less concerned with it when you're buying. And because remember, title insurance, unlike most of our insurance, we buy as a backwards looking insurance. When you buy title insurance, it starts the day you buy the property, it goes backwards. By car insurance, it starts the day you buy it, it goes forward. So the title company, when they issue title insurance, when you buy it, they're really insuring the title that from the old owner who's give it to you. However, when you go to sell it out of a trust, it stands to reason that they've got to make sure, hey, who's the trustee of this trust? Is he still the trustee? Did this person die? Does he have the power to transfer the property? Did he ever have the power? Does he still have the power? Is there a new trustee? Does it take two trustees? So then they need the details of the trust. And they need to know it's in full force and effect. They need to know that the trustee is the current trustee and that he has the power to transfer the property. So that's the three main things they need to know. And generally, by providing them the certificate of trust, it will satisfy those needs. And the certificate of trust is also going to have a tax ID on there because they need to know if they're to sale that they're required to report to the IRS, they need to know where to report that to. So, all right, so talked about this. Letter of direction. Let's go back to that for a second. So, assignment of beneficial interest. So the interesting thing about a trust is, remember I told you the beneficial interest, that's what we own, that's us in the transaction. You can assign your beneficial interest. The trustee can still be on title, someone else can own the trust. Doesn't appear on public records, doesn't show up, things just keep going along. So it's possible to buy and sell, it's property to sell the trust effectively or transfer part or all of the trust without changing anything on public record. And there's cases when you might want to do that. We've done that in many cases. So, a letter of direction. In our trust, remember I said the trustee does not have discretionary authority to transfer the property or to do anything with the property. Since it's just a title holding trust, the trustee's really only job is to transfer property when we tell them to transfer the property. So I'm a trustee on a lot of properties, all over the United States. But I don't file taxes on them. I'm not liable for them. The only thing that you could be in trouble really is if I went and transfer the property without the proper authority to transfer the property. And we give the authority with a letter of direction. So if it was a trust that I was the beneficiary of, and I wanted Roger, who might be my trustee on it, if I wanted him to sell it, I'd give him a letter of direction saying, show up the title company and sign all the closing documents for this closing we got coming up to transfer the property. So that protects Roger because in this type of trust, the trustee needs a power to make that transfer. So, all right, sorry I'm pressing buttons here. So here's another thing that is why trusts are allowable in all states. No state can pass a law that it impairs the obligations of contracts. And a trust is just a contract. Well, I'll tell you, I'm not good with this. So, and this is constitutional law. So these are well grounded in the law. Don't let some title company or somebody who doesn't know what they're doing say you can't use a land trust or a land type trust in Missouri. It's not true. Yeah, with some underwriters, they would prefer, or they might not want to insure title insurance, but there's tons more out there that will. I've been doing this for a long time and I've seen hundreds and hundreds of transactions. They're all insured, there's no problem. So, and they're backed up by constitutional law. So, and we get a little more in the weeds. I'm going over a lot of information fast when we're in class and we talk about the more detailed why some Missouri don't like a land type trust. So. The revocable grantor trust, we talked about this earlier, revocable can be changed. The grantor part is an IRS classification. And it's a living trust too. It's a form of a living trust. Now it's not a living trust in the sense that it's an estate planning trust generally, but it's a living trust in that it's created while we're living. So the tax implications is if it's properly structured as a grantor trust and all the income and deductions flow through the trust, there's no separate tax filings required. That's why I said earlier, in general, trusts are great for holding things, not doing things. If you start doing things in your trust, like, oh, I'm going to run my management company out of a trust, probably not want to do that. That's the you have to file 1041. Then it's the highest tax classification above, so if you want the highest taxes, create a business trust. So we use trust not to do things, just to hold things. Now there are situations where a trust can, but probably none of us in this room would create a business trust that would be operating a business out of a trust. So why consider trusts? They're private, under the radar. And I say this a lot, but privacy is a huge benefit. It could protect you from frivolous lawsuits. And what do I mean by that? Let's see if I got it more on that. There's people out there, they just sue, that's what they do. And they're just looking for their next meal ticket. And if you happen to be the party that gets that, and they go to their attorney's office and I'm not talking about, claims, I'm talking about frivolous stuff where this is not a real claim, but they can get some money out of you or your insurance company or whatever, and they go to an attorney and say, hey, we want to file a suit here, and on the owner of this property for XYZ. It was a case of a dog bite that happened. It wasn't the tenant's dog, it wasn't the owner's dog, but the dog was on the property, so they sued the owner of the property. So the fact that it was in trust, it went on for 2 or 3 or 4 years. The trustee changed, and in this case, the venue of the lawsuit changed to another state. It just went away. It was a large suit for several $100,000, but it made it very hard to track down people, and it gives you a lot of privacy from those type of suits that you're not really liable for. They don't protect you, if you go out and do something wrong, or because they can be penetrated through. But the privacy they give you is, in my opinion, is second to none. And they're easy to create. And you can buy and sell, even if you maybe have a leaner judgment in your name from prior business, prior marriage, something like that. It allows you to really operate on the radar. And they're easy and free to create. And they work great, like I said, in conjunction with LLCs. So where to learn about them? Well, when it's a surprise, I teach a class. I haven't taught a class that I think 4 years now. I was teaching it every year for many years, and circumstances of my life changed, and then I just 1 year passed, another year passed, and haven't taught it in a while. But lawyers and trusts. So trusts are not big ticket items in the accounting and legal profession. Yes, there are trust attorneys that focus on trust work at big banks. That maybe do wealth management for large folks that have huge investments and lots of property and money. And then there's the trust attorneys that do estate planning and will help you create a estate planning trust. Which if you have some assets, estate planning trust is a great thing to have. But that estate planning trust goes under the type of trust I'm talking about. Because estate planning trust, most folks do that to avoid probate, so they can pass stuff down to their heirs. The issue with the estate planning trust, it doesn't really give you any asset protection. It doesn't really give you any privacy, because generally people go out and they go, well, my name's Dan Bryan. I'm going to create the Bryan Family Trust. Put my car in it, house in it, my boat in it, my second house in it. Well, now there's 5 things in the Bryan Family Trust. They're all on title. There's no privacy there. It's the Bryan family. And if there was a lawsuit or something happened, it could potentially, threaten all those properties, or at least encumber them in such a way that you might not be able to sell them, or might not be able to do something with them. And that's the real problem with owning something in your own name, too. I mean, anyways, all of us drive cars. That's one liability. If you're a driver, it's really hard to. Wasn't me. I mean, you're going to get sued. Now, hopefully, you have insurance, and hopefully, it covers that. But they can come after you personally if they think you have assets, and they go above the limits of your insurance. And guess what? If a malicious business is filed a lawsuit like that, maybe someone's killed or something, you can't sell anything that's under your own name because there's a judgment attached to it. It could put people out. It's put people out of business before because all of a sudden they were in a situation where, they weren't able to do anything. It's not, I'm not saying this is common or you're gonna run out and be worried about it, but it is a concern, especially if you've got considerable assets in your own name. There's one thing to tie them all up, a judgment against you, your personal name, if you own assets in that name. Even if you finally win the case and it's thrown out, but the time during the lawsuit's going on, it can really have a potential issue for you. So, and it's difficult to find attorneys that use trusts like we do. Most attorneys are going to think of the estate planning trust or maybe a big trust that manages a wealth fund or something like that, or is set up as a conservator trust or some special purpose. Most aren't aware of the Illinois type land trust and specialize in it. We do have attorneys that do, though. Roger's one of them. And one of the other guys who was premier in Missouri just died last year. So those two are the two guys in Missouri that I went to that I know. And so there's just not a lot of information. That's not necessarily bad. It's just that you've got to know where to find those attorneys when you need them. So, and I always have an attorney at my classes. So Roger's usually there. I've had other attorneys. I may actually try to get some more attorneys there because I'm probably going to see if I can get it approved for the continuing ed for attorneys. I just don't know if I have enough time in the next 2 months to do that. So I should have done it a long time ago. So because it's, I don't challenge me. Challenge is what I bring up in class or challenge me here because I learn all the time. And we'll tweak different things in the trust to make them, make them a little better. Just like your landlord agreements. I know a lot of landlords out here who've been in business a long time. We're always tweaking our agreements. I mean, we've been in business for a while. You got it pretty good. Something changes, or you get taken advantage of by a tenant or something. You make those changes, and you try to improve as you go along. So, and that's what I've done. I always revise the workbook every year. I usually spend probably first year I probably spent 100 hours on it. But then, I probably every year I've spent 10 to 15 hours. Going through it, because I always take notes when I'm doing the class, and throughout the year when I get calls from students and from other people. I mean, I get calls from other states sometime, just say, hey, Dan, can you look this over? We put the property in trust, but we never created the trust. Now the trustees died, that kind of stuff. So, and that stuff could generally be fixed, but if they'd done it right the first time, it wouldn't have been a problem. So, but I try to make sure that the problem doesn't happen to me and certainly anybody that I'm helping out. All right. Let's see. We go over history of trust theory. We go over more about the history of it. The parties, we talked about the elements of the trust, the creation, legislation involving trust, how to title it, whether you're going to use a quick claim deed or a warranty deed. And there might be situations where you might use one or the other. Because remember I said about quick claim, even though you're not warranting title, you already have title. I mean, presumably you got title insurance when you bought it. There might be a reason to use a quick claim, depending on what you're trying to make it look like a public record. See, when I look back at a piece of property, I kind of dig into the transfers, and I usually can tell what's going on, with a piece of property. So especially if it's been property's transfer a lot, usually tell by how the deeds are transferred what's going on. So sometimes, if you like, for instance, if you folks own properties in your personal name and all your tenants know you own the properties, I'll show you how to get the properties out of your name, put them in trust, and also tell the tenants you don't own the properties anymore. But you're gonna manage them for a while because you've been, the new owners want to let you keep you on as manager. So there's different ways we do things, but then you get to reestablish your relationship between you and your tenant. When a tenant knows you own a property, and maybe if you were a starting out landlord, you let the tenants take advantage of you and do things. I did. I know that was I took a while for me to learn is the tenant part of the business. I always thought I was, pretty good with people, but I didn't really know the hiring of the tenants. I can fix properties. I'm an electrical contractor, plumbing contractor also. So that's what I like, the technical side. That's why I got into trust, the legal side. But I wasn't really good with the social side of with the tenants. I'm much better now. But none of my tenants know I own the property. And guess what? I don't. I can swear on a stack of Bible, I don't own the property. And they might think I have some ownership interest in it. Sometimes they say they do. I say, yeah, I'm a junior, I have a junior interest in it, but I'm the manager. I get to make all the management decisions. You know, unless it's a big decision, I have to check with the other managers, because I'm a junior manager. Now I say I'm a junior manager, well, I probably own all the, I probably have all the hats to have all the ownership interests in the property under my control, but I don't own it legally. And while I might be the beneficiary, it might be an LLC that's got a couple parties in it. So and see, they don't know that. They can't see that. And it leaves me in a much, much better position with tenants in terms of my relationship with them. And they, you know, I say, look, I can't make the final decisions. I might have to check with somebody, my wife maybe, or an imaginary phone call. But it leaves you in a much better situation when you're dealing with people. You know, it's a third party negotiation. When we were doing short sales, when we're the negotiator between a buyer and a lender, and the buyer's in default, a third party makes a big difference in negotiations. So we go over the operation of the trust, how to insure it, finance it, what the tax considerations are, how to deal with the title company, renting of it, property management, and then the beneficiary agreements, where you might have multiple beneficiaries. If you're doing some kind of joint venture or owning property together, then you might want to have a separate beneficiary agreement that says what your roles are. We talk about the advanced strategies, how to name them. The domicile of the trust, that's where the trust lives. That's where, if there's a lawsuit, that's where the lawsuit need to be filed. And the domicile could change, which is interesting. Imagine the trustee's domicile, the trust is domiciled in Missouri with a Missouri trustee, and then then that trustee dies, and the successor trustee's in California. The domicile trust might be now in California. Now with real estate, since it's an immovable object, it might not avoid all issues with a piece of real estate, for the real estate specifically, because it's still in Missouri. But with personal property or dog bite, things that aren't related to the property, it could be very advantageous to you, because it could change the venue that a lawsuit would have to be filed if there was some issue like that. We talk about how to select your trustees. In fact, a lot of my students, or a lot of folks in class, a lot of my trustees are people I met in the first trust class I took years ago, 20 years ago. So, and a couple of those people I still use today, and they're in other states. So, that's the other thing about having to get in the class. You've got trustees at your disposal. You know, you get to pick somebody you like and trust, and kind of knows how this works. So. And of course, you can always find an attorney that'll be a trustee for, you know, for what a nominal fee. So that's always a consideration too. And you might even exchange trustee services with other folks. So that's what I do. I've got, like I said, I'm a trustee for a lot of folks around the country, and then I use them as trustee if and when I need them. So talk about provisions of the trust, spendthrift provision, which is an asset protection clause. How to do tax-free exchanges. Those of you that exchange your real estate, your 1041 exchanges, the trust doesn't inhibit that in any way. And it's the IRS ruling on that also. So talk about having co-trustees and co-beneficiaries, successor trustees, using a director and then issuing trust certificates, which I've never done, but you could do it. And I guess I jumped ahead and got this, but most people say, oh, I already got an LLC or corporation. Well, corporation is probably not the best way to own real estate for tax reasons. So an LLC is pretty much the probably preferred entity for most entities now, because they can be taxed any way you choose to have them taxed. So even as a corporation, you'll choose, but generally a corporation for investment real estate is taxed at a higher rate. So again, why do you use trust? Even though you have an LLC, well, you get more privacy. And it's not registered with the state. Less exposure of the LLC. You keep your LLC down below the radar. So I've got LLC people have never seen or heard of because they don't do business. They're the beneficiary of the trust. I have other LLCs that do business. I mean, I got a management LLC I use to manage my properties, but you know what? It doesn't own anything. It doesn't own any cars. It doesn't own any trust. it's got the right to manage trusts. It manages property, they're in trust. And those trusts are held by another LLC. So see, if I was gonna get in trouble, I'd probably get in trouble with the management company. I violate fair housing, or someone thinks I violate fair housing, or somebody thinks I did something wrong, or that's the operating part of the business. My LLCs that are, have ownership of trusts, they're below the radar. And I might have one LLC might own the beneficial interest of 5 or 10 trusts. We talk about, how to decide how many entities you need and what might be best for you given your situation. So you might have a separate LLC for every trust. Probably not, especially when you're getting started out, because you probably don't have a lot of equity in all those properties. But as your equity grows in properties, or if you have a 24-unit apartment building or something, yeah, I'd have a different LLC under the trust in that agreement. But so it's an inexpensive layer of defense. It's great for joint ventures. It's not as costly as individual LLCs, and combined with trust, like I say, it gives you great privacy and asset protection. I've got to beat this one to death, but personal property trust. It's the same kind of trust, a little different language because we're not holding real property. We're holding personal property, and in general, personal property is everything else that we moved, and it's boats and cars and stocks and CDs and intangible shares, anything that our furniture, chainsaws, Sea-Doos. I mean, and it could be there's some advantages of putting dangerous tools in trust too, like Sea-Doos and things where people can get hurt. And probably don't protect you if you do something, but let's say you had your Sea-Doo in a trust and your neighbor borrowed it and they got hurt. Well, they can't sue you really, you can sue the trust. So the trust could offer some protection. I mean, maybe they could get through and get to you if they can prove you did something wrong or there was some reason to go through it. But in general, you don't own it, a trust owns it. The fact that you have the beneficial interest of it is a whole different deal. And we'll talk a little bit about gun trust. If you guys are gun, and automatic weapons and how to have stuff in gun trust to get around. I should say get around. There's that's a whole other subject. I just had to add that to the class a few years ago. But for those of you who might be interested in that, so it's about dividing the assets up and providing privacy, protect your risk. All right. Living trust, I mentioned this already. This is a way to keep your living trust private. It's below the radar. It might be in place of your LLC. Or if you've got a lot of properties, you might have in case of folks that have LLCs for their properties now, they probably have a successor, the members, they name their living trust as the beneficiary under the probate transfer law. So you can still have living trust at the very bottom, and you can use them with LLCs and trusts, depending on how many layers you think you need in your situation. So the living trust should be at the very bottom, because that's really, if you have a living trust, it's where you tell everyone where all the assets go, and all of them could flow down through it. It's a really good structure, and then all the decisions get to be made at the living trust level, like when you die, or when you and your wife die, or when you both die, what happens to all the assets and how they get divided up. But it's all put in one thing. All your LLCs and all your title holding trusts, they don't need all that language. It would be a lot to keep up with, which changes if you had it in all those. So you want to put that kind of language in your bottom estate planning device, which is generally a living trust if you have one. And you're not titling anything in that trust. So the public doesn't see it. They don't see this aggregated assets. They don't see all your assets. They see all these other trusts out there. They can't tie them together easily. All right. I think mostly we've covered liens and judgments. If you get a lien and judgment against you, it doesn't attach to the property because you don't own the property. It can real estate brokerage laws it might help you with that. We go into that a little bit if you're a real estate broker and think you can't do certain things. Can get around seasoning problems sometimes with loans, if that comes back. Buying property subject to, is a benefit. I think I had a slide, I might have skipped over that. That's where you buy a property, you take over somebody's loan, you don't pay off the loan, you start making payments of their loan. It's a great way to do that. Instead of putting it in your name or something, you transfer it in the trust. There's a whole process to kind of do that. So it's kind of under the radar. You're not, you're not trying to hide it from the lender, but you're not defrauding the lender. You still have to pay the loan, but you're not also not raising your hand and going, "Hey, I took over this loan with somebody." You're just transferring the property to the trust and then continuing to make the payments. And I bought a lot of property subject to. So, all right. I talked a little bit about property management, how it helps with that. It helps greatly with tenants. They don't see me as this ultimate decision maker. So, I mean, I've had several tenants go, "Man, we want to meet those partners, or we want to meet the owners." And I go, "It's a private investment group. I mean, it might be just me and me and me and me, but it's still very private." So I said, "No, I'm the manager. I'm their face. That's why they got me here." I said that it's a very private group. There's multiple parties to it. There is. If I stretch out all my trusts, I've got lenders, and in some cases I've got partners on properties too. So just depends on the property. It's great negotiation. I might have some examples here. Oh, there's a subject to retake title or existing loan. And I jump ahead and I'm talking about all this stuff pretty much before. Sellers take order finance can do that. They can hold the notes in the name of a trust if they want. That would be a personal property trust. A note could be owned. Instead of you being owed money, the trust is owed money. So you open bank accounts in a trust. Gives you a lot of privacy. When you go in the grocery store, you got some fancy trust name and you sign as trustee. Looks kind of cool. I don't do who signs checks anymore though. Landlord benefits again. You're just the manager, not the decision maker. Have to get approval. Might be able to if the owners approve. You can be the advocate for the tenant. It's less adversarial. I'll go to them and say, "I know you want the carpet replaced or whatever. Let me go to them and talk, and we'll see what we can do." It's a much better arrangement, especially if they're unrealistic in their demands. I try to with my tenants. I don't want them to move, and if they're good tenants, I try to accommodate them if I can. But if it's unrealistic or it's not cost effective, it's a way of bringing them back down to reality a little bit. The buck never stops here. It keeps going. I'm not sure where it stops, but it ain't here. I've said to you, I had an inspector that was trying to make us replace a stack down in the city because he didn't like the way it was fitted. It was an old cast iron plumbing stack. Well, I'm a licensed plumber, not in the city, but this was original. It wasn't rusted out. It was in great shape, and it was 50 years old, but it wasn't like it was leaking. He just didn't like the way that the vent was tied in. Well, it had been passed years ago and worked fine, and he wanted it replaced. And we were going to tear out a wall in a bathroom and old these historical houses. And I said, "Well, I said I got to have some. You got to give me the code on that. I got to meet with the board of trustees next Tuesday." And he doesn't know there's no board of trustees, or it's a single member board. But it worked. I mean, because they didn't really have a justifiable code reason to do that. I mean, it was grandfathered in terms of just because the code changes doesn't mean you have to go ahead and change everything that doesn't meet the new building standards. And it worked. He called me back and said, "Well, we're going to let you get by with it this time." I'm like, "Oh, thank you very much. I'll let the board know." And so just get that to me in writing and cite the code reference so we can get it over to the board of trustees. So it was an easy. He didn't see me as the guy fighting it. I got to get to the board of trustees. Remember, I'm not the trustee of that property. He's the trustee of the property, but I'm not that guy. So, and I always tell my junior manager, "I'll see what I can do." And then say I use the story, I'll check with the trustee. So the trustee, in our case, the trustee didn't have any power. But they don't know that. You don't know what you don't know. So I told the Florida dog bite story. The trustee quit, so it changed the court venue to where the new trustee was living. I was a public inspector there. I said, need in writing. This is one that came up with another person in Illinois. There was a tax bill that came up after closing, like 2 years later or a year later. And he said, well, I know the property was owned by a trust. And he said, well, the trust has got to pay it then. Well, guess what? Property been sold. Trust was dissolved. Trust didn't have any assets. The city just wrote up the taxes. So he didn't pay him. And I know this guy, he got pulled over by the police, and he had a vehicle owned in the Allied Law Enforcement Trust. I don't know who that was, but you know, when they come up on in, they say, is this your vehicle? Looks like it's owned by the Allied Law Enforcement Trust. Yes, sir, we created that after 9/11. Oh, well, slow it down, son. Slow it down. Appreciate what you do. All right, thank you. So I mean, see what I mean? The name of the trust, it says something. Now it doesn't say it's not, but it's Allied Law Enforcement. I like law enforcement, you know, and sometimes they ally together. And I just happen to have a trust with that name. So works pretty well. So sometimes I spend more time trying to figure out what to name certain things. Sometimes you get a piece of property like, I got to deal with the city on this one, or I got to deal with, don't want to make it look like it's owned by little old lady, big bank, out-of-state company. Maybe it looks like it's owned by a not-for-profit. I mean, see, you could. Well, I'm not lying. I'm not defrauding anybody. I'm not saying it is, but the name, people just read something into the name. So it's sometimes I just get lazy and I pick one of the words that's in the subdivision name and I throw another word with it. And that's when I'm lazy, though. So, and this stuff we could get sued for possibly, or you know, we could be at risk. And if you've got stuff segregated and in trust, you could sometimes separate your risk and give you some asset protection. So, are you in real estate? You drive a car. And I use a driving car example because it's really hard to get rid of that liability to drive a car. That's why we have insurance, but you can't farm that off on somebody else. No, my body's owned in a trust. It was driving that day. Now that's not going to work. Most things, a lot of things you could. You know, create an LLC, create some other entity to protect your liability. But driving a car and you got in a bad accident and it was serious, that's one thing that's hard to get out of. So, and you can fix messes and get your name on public record. And so here's what the class consists of. I don't have any registration forms right now. John kind of called me a few weeks ago, and I just didn't really time to set up the place. We probably will have it here, or we'll have it at Keller Williams' office that I'm out of. So that's where I've generally been having it. But I'm a Keller Williams agent, broker too, but really only for my real estate. So not looking for any real estate business from others generally, unless it's a friend or family. So if you're any of your real estate agents out there, I'm not looking for any of your stuff. So it comes with a manual. Like I say, I add to it every year, workbook and all the sample paperwork that I currently use. And there's a lot of networking. It's all day. We usually start at 9 and go to 5 with breaks. But then most times we go out on Saturday and Sunday for anybody who wants to go out and have a dinner or drinks or whatever and just talk real estate. Some of us are crazy that way. So. And several people in this class have been to my class, and I always get folks that return and come back. And I go to a lot of trust stuff too. It took me a little while to get as detailed and knowledgeable as I am, but I like real estate. The stuff interests me. I don't know why it's kind of crazy, but there's not a lot of good education on this. The preeminent guy in the country, in my opinion, died about 5 years ago, Jack Miller. So, but there are a couple other guys around the country that teach trust. The second preeminent guy, Dyke Spotiford, is retiring because he's got Parkinson's. So that's the two of real estate guys that really know it. There are a few other guys out there that have taught it. There's a guy, Lou Brown. You guys know Lou Brown. I know he's got a trust class. That was the first trust class I took. So that's where I got my kind of started, but changed a lot because Lou tries to kind of boilerplate it for the whole country. And, Georgia's got a little bit different trust law down there, so his trusts are written a little bit more catered to that. I used it for a few years, but I modified mine going forward. As I learned more and went to classes and just, I never really had I never had to litigate the trust. So, and I don't think of any of the people that I've dealt with have had to litigate the specific trust. So it's not like it's going to get you in trouble, but having the trust document written right, because it could cause you some issues when you go to sell it if you don't have the paperwork. But that's the same with an LLC or other form of entity too. You have to have the proper paperwork. If it's not you and your personal name, you need to make sure you did the paperwork right. All right. So if you guys want to email me or text me, I will make sure. And also, John's going to send it out too. I'm going to try to figure out the location and get some registration information out in the next.
Okay, do you have time to take a few questions from the audience?
I do. Oh yeah.
Let's see a few things.
There we go. So, questions.
Write it down. Okay, who's got a question? Okay, of course, we always
Yeah.
Dwayne.
My hand was waiting to go up.
Get things off there. Here you go, Dwayne.
3 quick ones for you, Brian.
You can call me Dan now. Go ahead.
Oh, yeah, I'm sorry. You're not my age yet. But you're getting.
Yes, sir. Mr. Stiers, please.
When you're doing this closing, we need to be cognizant to have the lien waivers in the name of the trust, correct?
What's that?
If you're going to be selling that property, you need to make sure lien waivers are in the name of the trust, because I'm assuming.
Well, the lien waivers will be. The lien waivers will be it'll be the name of the contracts that you're getting a lien waiver on. That what we're talking about, or?
Yeah, but they're gonna give it to you, and the title company wants to see that you did that, typically.
Oh, yeah, I guess so. I mean, really, the lien waiver may or may not have to have the name of the trust on it. It would typically just have the property in it and say they did work in such and such property. It could reference the owner of the property.
Okay.
But like a lien waiver, as a property manager, I might hire work to be done. And yeah, I mean, it would release leads to the property, so it could name the seller. If it did have the seller's name, it would be the trust name.
Okay, and the other thing that popped into my head this time was the title insurance. Does that go away when you stick it into a trust if you've already bought the property?
Yeah, very good question. Very good question. So that's the reason that once you deed out of the property, if you use a quit claim deed, let's say you bought title insurance and you quit claim the property after you bought it into a trust, you would effectively the trust wouldn't have title insurance again. If you general warranty a deed, then if there was ever an issue, it would since you warranted it and you have title insurance when you bought it, that would allow it to flow back through. So that's generally, and I talked to you about that. That's generally how we recommend you put your property in the trust in most all cases. But a lot of the gurus out there that teach, it's really easy, just put that in the trust. Well, not realizing that you could lose the benefit of title insurance.
Okay, the last one real quick is I've taken his class twice, and it made me smart enough to at least know what to talk about. And if you're gonna go see an attorney, it's really good to know that up front. And I really thought he had a tremendous class both days. He answered all the damn questions I asked.
Thank you, Dwayne. I appreciate that. You know what? I tell you, the first class I took, I was so nervous, and I still have a little bit, but it's just, if I don't know it, well, I'm out there digging and trying to find out. We get questions. I'll call Roger if we get something come up over the years. Usually we get a question now, though. We usually have an answer for it. And Roger will call me sometime. We'll brainstorm on stuff because he gets clients that. So I get the benefit, which I really appreciate, of all the people that came to my class and stuff. People went to Roger to have them do stuff, and we brainstorm about real estate stuff in general, legal stuff in general. So and Roger's doing a lot more real estate law than he used to. So he's got some more help in his office and stuff, and he's a good resource for you guys, and he's a good friend too. So he's a detailed and stuff. So like I say, Phil Gephardt, I don't know if anybody knew Phil Gephardt. I'm sure some of you did, but he was the other really attorney was up on these kind of trusts, and unfortunately he died in September. So it's hard to find, and there may be a few scattered around because we are close to Illinois. So in Illinois, this Illinois land trust, we're creating an Illinois type land trust. Missouri doesn't have a statute, so we can't say it's a Missouri land trust under statute 684, but it doesn't really matter. We're creating with the benefit of the Illinois land trust and all the court cases since it was first created, so. And we talk about why it was first created in the class. It's an interesting story how Chicago Title came up with an interest. They came up with this concept, some attorneys are at Chicago Title, to get around some financing issues on a big parcel of land that builders were trying to subdivide it, get financing and sell it off in portions. And the heirs that owned it, there was, people that died and got married, and it was very convoluted. And they created this concept of this land trust. Which, even though the trust concept has been around for years, there's few caveats that make it an Illinois like type land trust, and we talk about that. As opposed to most trusts, but it's like everything else, like we talked about deeds. The devil's in the details of the document. So, in general, the trust we created, there's title holding trusts, and the trustee has no discretionary power. Their sole job is to transfer the property when they're directed to. So that's one of the things. That's one of the main aspects of the trust that make it different from most trusts. And then one other that may not make a lot of sense to you, but in a land trust, the beneficiary holds what he owns is personal property. Even though the trust owns the real estate, real property, he only owns personal property. So it allows you to move it around with better transfers of beneficial interest and all that kind of stuff. Where in most trusts, the way they're worded is the beneficiary actually holds real and personal property, equitable interest in the property. And because of that, it's harder to transfer the interest because remember, real estate's immovable. So with the land trust, we can change beneficiaries across state lines and do some interesting things that you can't generally do in a regular type trust the way they're worded.
Okay, anybody else have any specific questions for Dan? As you can tell, he can talk all night.
Yeah, sorry,
and he talks two full days.
Yeah.
Okay, Dan, two questions. When recording your deed of trust, first, do you have to name a trustee legally?
Okay. When you're recording the deed, not talking about deed of trust. Deed of trust would be for mortgage and talking about when you're recording the deed and putting it in the trust.
Yeah.
Okay.
All right.
Okay.
Okay.
So do you have to name the trustee? You should. I don't know in Illinois if you can get away with it. So here's the challenge. In a trust, it's not a statutory entity. It's not, there's no statute, at least in Missouri, that defines it exactly. So the trust can't, since the trust has it's not a statutory entity, it's not allowed to hold title. It's not a competent party to hold title. LLCs can hold title because the statute says that LLC is a separate person. A corporation can hold title because the statute says a corporation is a separate person. We're a separate person just by our nature. That allows us to hold title. A trust in Missouri, there's no statute that says it's a state created entity, so it technically can't hold title, but a trustee can. Because a trustee is one of those competent parties, an individual, or so you have to have a trustee in a trust, or it's invalid. It's not valid. Now, in Missouri, there was a court case where a trustee was not named, and the ruling in the case was that just because it wasn't named in the document of the deed, it didn't invalidate the trust. So, but that's risky. In some states, it may, and I don't know if there's anything, and I know you're out of Illinois, I don't know if there's anything in Illinois that would say it. So here's what we did. We hide the trustee's name. See, there's more to I've talked fast, I know. There's more to us, there's more than we've talked about. Now, it doesn't work everywhere, but we put the trustee's name on page 2 of the deed. Why? Because we can. We draft our own documents. So at the top of the deed, it says grantor and grantee. The grantor is Mary Smith and Jim Smith, and they're granting the property to this, cannabis trust. This trust created, whatever today's date is, May 21st, March 21st, 2023. And normally after that, I would say Dan Bryan trustee. Because it takes all three of those things properly identify a trust. The name of the trust, verbatim, the date is created, you'll see under UTD and the trustee. But what we'll do is we'll put the trustee on page 1. Well, on the second page of the deed, We put some trust language in there. We don't have to. I can have the title company not put any trust language in there and do their standard deeds. But most of the time, I either have my ad language or I give my deed. And you might not do this for the first few, but, and then we name the trustee. It says the initial trustee holding title is, and we bury it in a paragraph. Doesn't make it any less valid. It's just doesn't stand out. Why does that matter? Well, when the court recorders indexes the deeds for recording, they don't look for a trustee if there's none right there. They just type in the trust name. And so when someone does a public record search, they might not pick up the trustee. Now, if they go pull the deed and read it, they're going to see it. But I would put it on the deed. I wouldn't want it's uncertain. See here, you don't want to go to court and have a court determine who the trustee is. Now, while you're alive, Keith is probably fine. If something happened, you could probably fix it. But here's the problem. What if you died and now someone else has got to go through that? Now a court gets to think, well, we don't even know what the trust is. We don't know who the trustee is, and that trustee is the only one who can transfer title. Normally, I mean, your trust is going to have more stuff in it. And on our deeds, we even name successor trustees, but you don't have to name all that in there. But I think you should have one trustee on the deed. Who's taking title initially? We try to put alternate successors on there too, so we don't have to fill more paperwork down the road. But our trusts all have provisions for if a trust dies, or if we don't like the trust anymore, we fire them. They quit.
Okay, one more. Also, I know you frown on it, and I get that, but can you legally be the beneficiary as well as the trustee?
Okay. Well, you get these hard questions. Okay. You can't be all a party. No, you can't. You can't be the sole creator and the sole beneficiary. Right. Yeah, you can't be all the parties. But what I said sole. If your trust names a successor beneficiary, you're not all the parties. Because really there's no reason for it to exist. So the law says it doesn't exist. You're all the parties. But see, if you have two trustees, if you have other things, or you have a successor trustee, a successor beneficiary. And here, if you're going to create a trust and have the beneficiary be an individual that can die, you'd be foolish not to name a successor trustee. And guess what? Now not a successor trustee, I'm sorry, a successor beneficiary. Because now you're in probate again. Why did you create the trust? If you're just creating one trust, you don't have no other thing underneath of it. You're going to put you as the beneficiary. And generally, if you're a landlord, you're probably going to put an LLC as a beneficiary. So you're not all the parties. It might be, that solves that problem. There's really no reason you'd ever want to do that. People do that. They weren't really thinking through it. So as long as there's a successor, you're not all the parties. Even though at one particular time you might be all the parties. But that's how a basic estate planning trust is made. Husband and wife goes in, they create a trust. Husband and wife are trustees. Husband and wife are beneficiaries. Oh, don't have a trust. They have a trust because they name successor beneficiaries, and the trustee part's not as big a deal, but they have to name successor trustees too. So that when they do die, it goes to their kids or to their favorite charity, and then somebody else takes over as trustee, either their kids or the bank or whoever they name as trustee. So you're not all. It's legal, yeah, because you're not sole. There's another, even though right now you might be. There's a reason for the trust to exist. So,
okay, anybody else? Okay.
Sorry, I go long sometimes, so cut me off.
Is there a way to keep the trustee from going rogue and selling the property or doing something you don't want him to?
Yeah, yes and no. Yes and no. So remember I said a trust should be somebody you trust.
Your trust, right?
And firemen, and even firemen, and make notice of public record if they go rogue. Here's the thing: I manage my properties. I got local trustees too. I like out of state trustees, my first trustee, because it gives me some separation. But I've gotten lazy and I usually use local trustees now. But I don't know how they would sell it. I guess they could. I guess they could call a real estate agent and say, "Hey, I'm a trustee on this property," but You know, I probably rent it, you know, there's probably ways to protect yourself. I do know of cases where that's happened, but this is how what happened was Jack Miller, the guy I talked about. He bought stuff, he said he owned stuff in 21 states over the years, in two countries. He was the first, at least in the service, he's one of the first, he said he was the first to own some property in Japan. So he went through all the legal side of it to get some property in Japan. You know, he said he owned like 3-4 countries in 21 states, and he goes, you know what? I lost money in 20 states and 2-4. I mean, if you can't do this at home, move. You know, because if you think you can do it in another state, you know, that's what happened to him. He bought some low-end properties like in, I don't remember where it was, you know, Louisiana or somewhere, and he just kind of forgot about it. Had a manager down there, and they were sending the money every once in a while, and fewer, and you know, for years and years and years. And then he went down there and come to find out a bunch of property's been sold. And a bunch of properties that supposedly weren't being rented, and the rent was a little higher than what he was getting. He said, but he didn't find out until the property manager died. So that was just a case of, you know, he had some properties he didn't pay attention to, and so it could happen. But it's, I don't know how it'd be tough, I think. I mean, it really had to be a smart person too. You know, the title companies. No, I think on the title company, and they don't even bat an eye when I do trust, because. You know, but I've got a good relationship that I've built over years. Roger?
What occurs to me, because I've had this case recently, and actually had it twice in the last few years. You don't need to deal with a trust to have somebody pretend they're the owner and forge a deed, and then.
It's happening all the
I
time.
mean, right.
It might even be harder in trust now, but
It probably would be harder because.
you see all the stuff now in the news about, you know, the property fraud.
Yeah, well,
That's the property.
I've had that exact case now twice, in more recent years.
Where were those properties at, Roger?
One, they were both in the city of St. Louis. And yeah, somebody just got it was a team of 3. One's a notary, one's whatever, each one played a role. And they acted like they owned it and filed paperwork accordingly, including a faked up notarization that they faked the name of the record owner. They looked and then the notary notarized that really was her signing it. And then everything kind of flowed from there. And then of course they rented the property to somebody. And there was somebody in there. And the owner in the most recent one was an older woman. She'd been living in this house in the city for a long time. Then her husband died. She still lived there for a while longer. And I think she thinks that they just saw her packing up. And, you know, the moving trucks came and she didn't deal with it right away because she was moving to the county or something. And sure enough, then it came time to try to sell the property and title company looked it up and said, you don't own this property.
And then I think in his case, the trust might make it less
If
likely
anything,
to go after it.
Well, because
you know?
most people aren't sophisticated enough to know how to, in
How
other
to do
words,
it.
you know how to say,
Right.
well, no, I'm not gonna give you the trust. I'm gonna give you a certificate of trust. And you know that that's a good answer for the title company.
Right.
But does somebody else know, oh, the trust, you wanna see the whole trust, huh? Gee.
Well, if you don't know how to fill out a certificate of trust, they get nervous.
Yeah.
Rightfully so.
Yeah.
If they think something's going on and you really don't know what you're doing, because a lot of people go out and get trust, even estate planning trust, because if somebody told them they need a living trust or something, they don't have a clue what it means. Oh, the voice probate, great, they get it, it's a binder, but they really don't, they don't update it sometimes. I mean, we've had cases where they never put the property in trust, they never funded the trust, spent $5,000 on a estate planning trust, big binder, nice, lots of paragraphs, nice. All the deeds weren't recorded. It didn't mean anything. It was still in the, you know, somebody dropped the ball. You know, whether the attorney said, hey, go out, record these deeds or whatever happened, or they quit paying the attorney, it never got done. So,
Okay, thank you, Dan.
yep.
Dan Bryant, you go ahead. May 13th, 14th, you can send out an email, you can get that going. I know we got a lot of people that are waiting to get their tickets to go to the circus. So let's get going with the, I got the tickets here. I got, Jim has got all the other sides of the tickets. I'm gonna let him draw them out. I'm gonna give you this. Is this working? Yeah.